as I said, this last panel of the morning before the lunch. And this panel, I think, will be very useful for people now because it involves what may be, with crypto, the trend of the moment in the restructuring industry. Also, we're going to put a lot of meat on the discussion that occurred earlier with the panel that Josh did on the trends in the industry, where there's so much discussion of things called liability management, credit-on-creditor violence, lender-on-lender violence, transactions. This is the panel that's going to give you the detail manned by the players who are really in the middle of that industry. And let me, last year we did a panel on liability management, which we defined as transactions that were done before a bankruptcy, hopefully to avoid a bankruptcy, but which really established new financing mechanisms, but that often the financing came ahead of existing debt, so one found themselves down the road being behind, instead of $500 million, $2 billion of secured debt. This year, the discussion has been, even though the transactions probably started about 2 years ago, this panel is going to talk about something that's been called either creditor-on-creditor violence transactions or lender-on-lender violence transactions. And those are the transactions where existing holders of existing debts may be doing a restructuring where they lend money, whatever, but get a position ahead of majority holders, may get a position ahead of minority holders in the debt. In other words, leapfrog their positions. And that's caused a lot of umbrage in the industry. And that was a lot of what was discussed, though not in a lot of detail, in the earlier panel. This panel, we really have the players in the industry. And I'm really pleased I can announce it. Going in no particular order, I thought I'd start in sort of the order we're going to ask people to speak on topics. So, obviously everyone's highlighted, but Damien Shaver, partner Davis Polk, co-heads Davis Polk's restructuring practice. He's been on the executive committee of the board of directors of New York ADI and executive committee of New York City Bar Association. He's twice been the outstanding restructuring lawyer. And I think we all can acknowledge that Damien is one of the most respected and sought after counsel for lenders and bondholder groups. And in the last couple of years where we've had so many things on Zoom, it's really been a wonder to watch Damien announce in court that to a judge in Houston, well, Judge, I have to slip over to my hearings in Delaware and New York in the next couple of minutes. Damien is just a killer leader in the profession. He's going to be talking about the transactions. Next to Damien, on the far side, is Jennifer Salendi. Jennifer is a founder and obviously named partner of the firm Salendi Gay Ellsberg, which is a premier litigation boutique. She represents private equity and investment companies in precedent-setting litigation, represents renewable energy companies relating to some cutting-edge litigation, and has extensive experience in RICO, bankruptcy, domestic, international arbitration across border disputes. Particularly important for our discussion here, Jennifer is probably the lead counsel in the majority of the cases where lender-on-lender issues have been raised representing the minority holders. So we're really pleased to have Jennifer as a litigator on our panel who can talk about how these cases have been going. Okay, moving this direction. Next. Next to me is Pat Dianello. Pat is president of Dianello Associates, an advisory firm providing wholesale restructuring and workout advice, portfolio management, and case management to accredited investors. He worked at JP Morgan Chase from 1987 to 2018. And he held the position of global head of wholesale special credits from 2007 to 2017. He's known for doing credits all over in particular, seen his name in credits representing in advance. Next to Pat is my partner, Mark Heblin. Mark is a specialist, particularly well known in representing bondholders and indenture trustees in cases. He's a past chair of the American Bar Association Trust Indenture and Indenture Trustee Committee, and recent representations for indenture trustees and bondholders have included such national bankruptcy cases as Chesapeake Energy, Hertz, Sun Edison, and Energy Future. Finally, in the middle is Doug McManus. Doug has moved over to the firm Decker. He is still one of the most renowned representatives of bondholder and lenders. He's particularly done a number of transactions representing minority holders. Anyway, that's our group, and we're going to try to discuss the issues of what this, whether you want to call it liability management or debtor or lender on lender violence transactions are, and go through whether some of the recent things, case law and feelings. I guess if we could start, Damien, could you maybe just go through your the architecture of some of these transactions and what people are talking about in terms of these transactions?
Sure. So why don't I do two things quickly just to kind of set the table. And let me set the table from a market perspective and then set the table from a technical perspective, the latter being less interesting. Everyone knows that sort of good old days, in particular with respect to credit agreements, it was pro rata. Everyone together, lenders all treated similarly, and there's a lot of credit agreements that we're going to talk about that require that and could be viewed to require that. Today, what we're really talking about today is largely non-pro rata transactions. In the liability management world right now, there are non-pro rata and pro rata transactions. The pro rata transactions are much less controversial generally, and they're generally used to put new liquidity into a business or help to extend maturity runways. The non-pro rata deals can be intended to put liquidity into a transaction as well, and very often are. But they also tend to create and then provide the company and the sponsor the ability to capture a discount. And so that's really most of what we're going to be talking about today. How have we gone from pro rata to non-pro rata deals over time? You could talk about that for an entire panel, and that's something I'd love to hear the views of the rest of the panelists on this. But by and large, you have sponsor portfolio companies where they hire their own lawyers, and they hire as a designation the lawyers for the investors. You have the rise of CLOs and other funds with extensive amounts of capital that they're looking to put to work. And all of that has just led to looser and looser and looser documents. And so I think we can all agree that 5 years ago, 10 years ago, 3 years ago, there weren't as many documents that would permit these types of transactions as there are today. And then on top of all that, you have obviously now rising interest rates and maturity walls, particularly in 24 and beyond, that we're approaching. And you've had so many of these deals that you could argue that, we used to talk about breaking glass with doing a non-pro rata deal. You could argue now that the glass is completely gone from the pane and there's no glass left to break. And so I think you have sponsors who are increasingly willing to use the documents and the technology that exists to effectuate these transactions, particularly when their backs are against the wall. So I think we're going to see more and more of those, and particularly in the next, call it 6 to 9 months. And so it's important to sort of understand that. From a technical perspective, I'm going to do this very quickly. The first building block you have to be cognizant of is treatment of subsidiaries. This is particularly with respect to drop-down transactions. At the bottom of that slide, you can't really see it, but you can see that there's the restricted group, which is the borrower and the guarantors, and there's restricted subsidiaries that are non-guarantors. That means that things owned by those non-guarantors are not part of the collateral package. So you can talk about moving assets from restricted subs to, who are guarantors to non-guarantor restricted subs. The other place that you can move assets is outside of the credit group completely to unrestricted subsidiaries. To the next slide. The other building block that we're going to talk a lot about is pro rata treatment. People think, look at a credit agreement and there's a pro rata sharing provision. And on superficially, that pro rata sharing provision might require or be read to require pro rata treatment under the credit agreement. We're going to be talking a lot about the exceptions that exist to those to that provision. You can often amend the pro rata sharing provision, amend it away with 51% very often, or just a bare majority. The pro rata sharing provision often reads such that it only applies to pro rata treatment within a class. So if you create a different class of security or a different class of loan, then that is outside of the pro rata sharing provision. And then there are exceptions that exist in every pro rata sharing provision, exceptions for open market buybacks, foreign exchanges, those types of things. So it's really important to pay attention, and it's very document specific. There are documents that provide clearly to, in my view, permit these transactions, and documents that provide clearly to try to avoid them. Moving to the next slide. I'm not going to spend any time on this. These are the two types of distressed liability management transactions that we're going to be talking about today. Drop downs and uptiering. To the next slide. Drop downs are the first. This is just quite simply dropping assets out of a collateral package, as I mentioned before, to either the restricted non-guarantor sub or to an unrestricted subsidiary. Once the assets are dropped out of the collateral package, again under the documents, they can be used. They can be used for raising money, they can be used for exchanges, they can be used in various ways. I was involved in one situation a few years ago where a borrower dropped a significant amounts of assets into a restricted non-guarantor sub. They weren't allowed under the documents to do anything with them, but they called up the secured lenders and said, hey, you don't want to file for bankruptcy now because all this stuff is outside of your collateral package, even though I can't do anything with it outside of your collateral package. The next slide is uptiering transactions. This is simply just what it says. It's creating new super senior debt over a, call it first lien credit agreement or a first lien indenture. You're effectively using oftentimes 50%, sometimes 2/3 of the creditors voting to create either a separate document or within their existing document a new tranche, and then directing the agent or the trustee of the existing facility to subordinate itself to the new facility. So you've created a super senior tranche of debt. That can be used, again, to raise new money. That can be used for up-tier exchanges on a pro rata or a non-pro rata basis. So that's kind of the technology we're going to be talking about during the course of today.
Okay, well, that sounds benign enough, but what does it really do? And then we can turn to Jennifer and Pat to talk about what the issues are against it. I mean, these are, I guess the transactions we've been talking about are ones where you assume generally maybe creditors and the majority of creditors in a particular class may be asked to advance new funds into a higher level of debt, and then the majority holds it and can also move their positions in existing debt into that higher level of debt, leaving the minority behind. Is that sort of a basic overview of it? And maybe Jennifer, you can talk about if that's the thing that happens, why all this litigation?
Sure. So I think why the litigation is precisely because the stakes are so high. I think that, the companies that are doing this, they need the money. There's a concern about bankruptcy, and the document is really the key issue. I think as Damien said, that it really depends on the language in the agreement. And overwhelmingly, when we have talked to the lenders who have been excluded from these transactions, the sentiment has been that the transactions came as a surprise. They weren't in line with their expectations under the credit agreement. That's not what they thought they were buying into, and that it's a value grab, and that it's improper, that it's breaching of the contract. And on the other hand, we've heard from lenders who are participating in the transactions or who are looking to initiate these types of transactions to manage liability. And their position has been, look, it's our duty to look at these agreements to determine what our rights are, and if there are opportunities to get new money in this way, then we're going to do it. And then the other lenders, this is sour grapes. They're unhappy because they were left out, but they bought into the transaction knowing. And so you really have totally conflicting views of what the agreements were meant to accomplish. And as a result, the bottom line is, I think this point about the sloppiness maybe of some of the drafting in the transactions, where there's a lot of opportunity to argue both sides of these issues and to say, the language isn't exactly clear. There are undefined terms. There are genuine differences of view of what was intended under the contract, and the parties are meeting up in litigation to resolve those issues. So I think both can be true, that some of the documents are drafted with clear rights, others not so much, and that's a perfect recipe for litigation.
What's Anna, you want to say?
Yeah, so doing what I do, advising creditors, in particular, a large asset manager, through several of these transactions, I've been involved on the inside of them and on the outside of them, and I guess it's a lot better on the inside than on the outside. But when you think about sort of the overall market reaction, depending upon if you're in the majority or the minority, just sort of taking a step back and thinking about it, the landscape has changed over time, right? The first big one that most people would sort of name is J. Crew. And I think when J. Crew came along, you had sort of this righteous indignation in the marketplace that no, that's not what was intended. This shouldn't be. The document shouldn't be distorted for this type of use. But obviously J. Crew happened, and it landed and it stuck the landing, so to speak. And that was the precedent, or a precedent out in the marketplace. And I don't think that any sophisticated investor can really, look at what has happened starting from J. Crew and really subsequent to J. Crew, and kind of say, as a sophisticated investor, that they weren't aware of what was in the documents, or that this wasn't a possibility. Of course it is. The documents sort of say what they say. But I think that we're starting into a new paradigm, right? Because I've always been of the belief that relationships matter in this space, even now. But now we've got this sort of value transfer mechanic, creditor on creditor violence, where it used to be you'd always have some inter-creditor squabbles, whether many years ago it was between banks and the term loan B investors, and the asset managers that bought the term loan Bs, and special situational investors between asset managers and special situational investors. But now you've got inter-creditor squabbles over value transfer that could be affecting asset manager to asset manager, or asset manager the asset manager, which is not something I don't think you've ever really seen too much of before. So those relationships where you see the same people deal after deal, could get a little bit, lines could get a little bit blurred. So it's going to be really interesting to see how that sort of plays out. I also think that what we're starting to see now in terms of a minority response is use of cooperation agreements. I'm not involved in this one, but there was it Brand Technologies, I think, where over 50% of the lenders got together and signed up to some form of cooperation agreement. I don't know the details of it, but a cooperation agreement will help, at least with respect to a layering transaction. It'll help sort of sway the required lender, sway the company towards the required lender deal with the people under the co-op, versus doing required lender deal away from them. Interestingly, though, it doesn't really help in terms of any kind of drop down. If there's a drop down being contemplated, a co-op really won't do much for anybody. I've also always been of the belief that if you're a company or sponsor that's looking to do one of these transactions, the lowest sort of cost execution, if you will, lowest friction execution, is trying to do a deal with required lenders. It's not risk-free because there could be a minority there that might rise up and litigate against it, so that we've seen in several deals. But I've always thought that doing a required lender deal where you've got at least a majority of your lenders on board versus doing a more aggressive sort of drop-down transaction where you might not have any of your pre-existing lenders on board would be a lower friction execution for a company and a sponsor to try to get past the liquidity issue if that's really what's driving it. I guess also I would throw out when we think about the minority and the majority, I think it's an unfortunate circumstance, but I think it's true that size matters because to the extent that you've got some size in whatever asset it is, a term loan, a first lien term loan, that size will get you a seat at the table. But to the extent that you're a smaller investor without size, you're probably not going to get that seat at the table. And I think that nowadays that probably works to disadvantage of some smaller investors, particularly if there's like a non-pro rata transaction or some type of layering transaction being contemplated. So I do think size matters, and I've been advising people to the extent you don't have size, it's sort of like a game of go big or go home. Either get bigger to get size and buy your seat at the table, or just get out, because there's a good chance that you might just be getting hurt in a transaction.
Hey Pat, can I ask Pat a leading question and then get Jennifer's reaction? So the leading question to Pat, you sort of
Only
said
it's an easy question.
So I think you sort of said it, but as an investor, I understand that around the time of New York, Not Your Daughter's Jeans or J. Crew, there was potentially like an aghast moment, like how, by the existing holders, like how could the document ever be used this way, right? But today, after so many of these deals have been done over the past couple of years, do you think it's fair to say that it is beyond caveat emptor? In other words, all of the investors are on both sides of these transactions at this point. Everyone understands what the documents say. Everyone understands how they can be used. And in fact, was organizing early and taking proactive actions and doing all these things because they know what the documents can say. And then assuming Pat says yes to that, I would then ask Jennifer, does that change as a plaintiff's lawyer in these transactions, the dynamic? Putting aside situations where the documents actually don't work, does it change the dynamic in the litigation? So Pat first.
So, yes.
I thought I could say it.
I feel like I'm the one saying
Honestly, I think it's really hard, and as I said, it's sort of it was an evolving sort of reaction, if you will. Given the transactions that have transpired since the first couple of big ones, it's really hard for a qualified institutional investor or a sophisticated institutional investor to say, oh, I didn't think that could happen. You'd almost have to have your head buried in the sand to not sort of understand the risk of what happens, but what could happen. I think a lot of investors take the approach of a little bit of a portfolio management theory, right, where you've got a very large diversified book of business, which all the asset managers have, and they'll say, well, not all of them are going to get into trouble, not all of them are going to have liquidity issues. There's a certain percentage that might fall into this category, and that's still a relatively small percentage. I think client selection is the first rule of fundamental credit. So I think everybody's trying to really focus on that, but there's always going to be some percentage that that falls off. And it used to be they would default and they'd go into bankruptcy. And I think what you heard from the panel this morning is they don't necessarily have to default or go into bankruptcy. It's going to be a liability management transaction that buys time and optionality for the sponsor. I mean, if you really think about it, and then I'll shut up and turn it over to Jennifer. If you really think about it, if you're a financial sponsor and you've got a portfolio company that's going sideways, and let's stipulate that there's no near-term maturity, because I think that that's a little bit of a different animal. So let's stipulate that the maturities are out a few years. Let's stipulate that there's no weird like opioid liability or that requires some type of like a class tort that requires some type of chattel injunction that you can only do through a Chapter 11. So put those issues aside. So if you got a portfolio company going sideways and you're the sponsor, why on earth would you ever file the company, knowing that you've got an absolute priority rule in bankruptcy and your first loss in your equity position, when you can do a liability management transaction and shift first loss risk up the capital structure to the secured creditors and buy yourself optionality. Now, one could argue that that optionality has happened in a few transactions and has yet to be successful. I would make that argument, right, and ignore PetSmart and Chewy and the Chewy IPO, so could knock that out. That was, in my mind, a bit of an unusual circumstance. There's a couple of other companies out there that have done liability management transactions, and it remains to be seen if the incremental time and optionality is really going to save the sponsor.
So I think it's fair to some extent what you're saying, but on the other hand, the cases that have hit the courts, the things that are being litigated, they tend to be earlier vintage, right? They're not 21, 22, right? So once you have litigation, once you have rulings on those litigations, there was a case after J. Crew where the deal was actually unwound, right? A North Star or something like the North. Can't remember what it was, but the point is that sometimes the litigation goes forward, it's successful. There's sometimes that it isn't, and what that comes back to, in my mind, is the basic point that yes, people need to be they're on notice, right? But what they're on notice of is you got to look at what your particular credit agreement says, and you got to look at it hopefully before you make the investment. Right, not when the transaction is taking place. But for now, we're still in the mode of litigating cases which were, deals that were done back in the 2018, 2019 timeframe. Will it change going forward? Will it be more caveat emptor? Yeah, for sure it will be, but it's still always going to depend on the wording of the agreement, and particularly when these cases are being litigated, let's say in New York State Court in the commercial division, where we have some, really excellent judges, thank you, Davis Polk, and where they're going to look to enforce the language of the contract, right? And that's why it matters and why you can have very different outcomes. When I talk to corporate lawyers, they believe much more so than I think the courts do that there's uniformity in these credit agreements, that everybody knows and understands what they say, but small differences in the language and how the deal itself is applied against that language can lead to different outcomes. So yeah, you need to look very carefully at what the language of the credit agreement says.
And that's why I think perhaps Damien's question is a bit unfair, because the caveat emptor assumes that everyone knows what the document says. And I think we're in early innings as to what the documents say. What is open market? That question is yet to be answered. And I think board riders and CERTA, we might get an answer as to what the documents say. But from my minority's perspective, you don't know whether you're going to be subject to an up-tier until it's too late, until the up-tier is announced. And I think the documents are largely broken in that regard. And I think this is nothing new. I think the creditor and creditor violence is not a symptom of COVID, as some of it suggests. And I think it's not limited to liability management transactions. It's backstops, it's convertible diffs, it's dip roll-ups, it's credit bidding. It's just the flavor du jour that now we have a majority taking advantage of a minority. And really, I think there's a case from the turn of the century that is, I think, relevant today. and it talks about how you have a majority bondholder cutting a deal with the insider, the sponsor in that case, and the majority bondholder agreed with the insider to have the insider personally guarantee the payment of the interest on his bonds, as well as provide him with a 6% rate, if he agreed to extend the payment date on the bonds by 5 years. They essentially picked the bonds, and the minorities in that case sued, and it was the trial court in that case from 1896 that said, nothing to see here. The document says what it says, the majority controls, and it was the Second Circuit that came out and said that there's a community of interest, whether it's partners or security holders, that creates a mutual obligation and imposes upon the persons a duty to act fairly. And I think there's been a loss of that. There have been a few cases where this has been raised and has not been dismissed, and I think we're going to see in the near term whether or not this is acceptable for the majority to take these steps. And I think it lends itself to the obvious conclusion that it depends what the transaction is. It depends on how much the majority is using that authority that the document has given them to take advantage of minority. Is it simply an amendment to allow a priming and new money? Or is it having the majority up-tier its existing indebtedness, perhaps even junior indebtedness in the capital structure, to a senior position? And I think that really is going to matter, and that's going to influence, I think, how courts determine whether something's open market, whether the amendment is a reasonable amendment that can be made.
Yeah. Well, just to focus on that, in the last couple of months, there have been 3 decisions about these types of transactions which denied motions to dismiss. So that someone decided there was an issue out there. Maybe we can discuss where those cases are, just so everyone understands that how this issue is sort of still out there in terms of what issues seem to be being argued.
Sure. Look, I think we should keep in mind that these cases so far have been decided on motions to dismiss. Somebody earlier asked the question, does that matter that it's survived a motion to dismiss? And it does matter practically, and it cuts both ways because, on a motion to dismiss, obviously all the plaintiff's allegations are assumed to be taken as true, and yet they're unproven. And none of the relevant language in the credit agreements has yet been construed definitively, right? Because on a motion to dismiss, it's just a preliminary ruling. And you have to go much further along in the litigation, maybe to trial or through summary judgment, before you have a definitive interpretation of the language that occurs and recurs in all these credit agreements, right? So I'm going to talk about some trends. I will call them soft trends, because the courts have pretty consistently found that the language in the credit agreements are not sufficiently clear to authorize the transactions as a matter of law, right? So the company and the participating lenders are not succeeding in getting the case thrown out at the outset. And that is significant for the reasons that Judge Chapman mentioned earlier. And 2, I think that we're seeing a pretty clear trend around amendments being used to sort of enhance and modify no action clauses, right? So attempts that have been made in these transactions to block the litigation and exclude the possibility that the minority will come to court to pursue their rights have failed. And what that means, these 2 trends, I think, is that on balance, the stakes are raised for these transactions. Insofar as the borrower and the participating lenders have to be prepared to see litigation through. That they're not going to get, some cases may get thrown out on a motion to dismiss, but that's not what we've seen so far, that they have to be prepared to litigate further. And in situations where almost all the credit agreements that we've looked at, there is a provision where the company is going to be paying for any successful lender to vindicate its rights in courts. That flips the traditional rule of litigation where everybody pays their own fees. So the company is now facing a scenario where if they don't prevail in the litigation and the transaction is found to be non-breaching, then they may end up paying a lot of litigation fees, right? So in the Trimark case, which I'll talk about in a moment, there's a settlement shortly after the motion to dismiss is granted, and I think a big reason for that is that's when you really start to see the costs of litigation weigh in, and going the distance is very risky.
But doesn't that cut both ways? Just curious, and again, not asking for any confidential information about the way it's set up, but like the minority holders, I presume, have to be willing to be on the hook for a significant amount of fees just to get the motion to dismiss phase and to continue through if they don't end up ultimately getting the company to pay for it, or if they are so successful, if the company ends up in bankruptcy, then they're not going to get those fees paid either way. So do you see it as, are institutions willing and able to kind of foot the bill for the litigation?
So I think what you're seeing is that it's a shared cost, right? So you have a large group coming together. And that in itself is a challenge, right? So I think the company and the majority lenders see this as just a natural obstacle to being able to pursue this because they're going to have to front the litigation costs. And in some cases, the majority lenders are also demanding that their legal fees, if they get sued, are covered by the company, right? But I think that creates a dynamic where settlement makes the most sense. It's really not a situation where I will be surprised if you see one group of lenders or another group really willing to see it all the way through to create the precedent that definitively establishes, because there's a lot of sense in working out something that doesn't raise the cost and the risk, to what? Losing the new money. I think the minority lenders have to ask themselves, is there an outcome here that's really not good for us, right? If the company really needed the new money, are we going to make them give it back, right? And that makes a very, I think, a fertile ground for deals to be made.
Well, it begs the question what the right remedy is, right? Because you could see a situation where a court would find that the new money component was, acceptable and in line with the terms of the documents, but the uptiering portion was not. So the question would be, if that in fact is the remedy, what's the harm to, at least for the majority, to actually try the transaction? There's no real downside risk other than the economics that you would lose if you're unsuccessful in the litigation. So I think remedy and settlement, I completely agree with you, they go hand in hand as to whether or not you prosecute that litigation, because from a minority's perspective, making that economic decision to fund that litigation, you have to understand what your upside is and what the likelihood is that new money is going to get knocked out.
Well, and in a lot of these cases, you've had the minority group was reaching out to the company proactively. They wanted to be included in the deal. So that's what they're seeking, right? They just want to have a pro rata participation. And that's always a potential for settlement.
It's also a dynamic, really, correct me if I'm wrong, right? But the minority, by definition, is going to have some portion of much smaller holders, generally speaking, right? And CLOs in particular that really do not want to take on that burden. And so if there's an off-ramp that is a treatment not as good as what the majority has received, but better than what, saying no to the entire transaction receives, a lot of times you find these guys just being peeled off because it's a lot easier for them to take the off-ramp, get some better treatment than what they otherwise would have gotten, and just not have to foot any legal bills on litigation. And there's a few transactions out in the market like that as well.
Makes sense. Makes a lot of sense. So quickly, just to talk about some of these cases and keeping in mind that they are preliminary. The Trimark case, and I'm talking about these not in the order in which they were filed or in which the deal came through, but the order in which the court has decided them. Because the Trimark case, which was filed after Board Writers and Certa, the decision came out sooner. And in that case, there was the company got $120 million of new money. And the participating lenders rolled up $307 $1.5 million into a second out super senior tranche. So they were exchanging their legacy 1L debt. And then, the excluded first liens found themselves sitting behind that money. So after the complaint was filed, the motion to dismiss is made, and the ruling allowed the primary contract claim, the declaratory judgment of primary contract claims to survive, which were premised on a number of different sacred rights in the agreement. And in particular, the one that's discussed most in the opinion related to modifications of Section 402 of the collateral agreement in a manner that by its terms changed the order of application of proceeds to the collateral. And the court basically said, I'm not saying they're right, I'm not saying the defendants are right, but this is language that's susceptible to at least two reasonable interpretations, and therefore I can't throw it out on a motion to dismiss. And the court also left open the possibility that there were other sacred rights that might apply. Importantly, because there was one of these modified no action clauses, there's a fair amount of time in the opinion that talks about, that traditionally no action clauses are meant to have a salutary effect. They're agreed upon ex ante by all of the lenders, and there's a purpose behind them that says, let's not have individuals running off and bringing litigation if it's not considered to be in the best interest of the group. But here the court found that there was neither ex ante agreement nor a salutary effect to the modification of the no action clause, and therefore found it to be unenforceable to block suit. I think some other important holdings in there were that the tortious interference claim against the sponsor was dismissed. The sponsor was found to be able to take advantage of the economic interest right under New York law, and found, so basically unless the minority group can find some fraud or other inappropriate behavior that would vitiate that economic defense that the sponsor has, the motion was granted without prejudice. And then also, without a lot of analysis, the court dismissed the covenant of implied good faith and fair dealing. And that's important because later cases have come out differently, and I think there's a difference of opinion. This is a doctrine that generally courts have treated very, very differently in different factual circumstances and different judges. So I think that's another thing to watch.
And by sacred right, you mean that the argument is that 100% of the holders have to sign off on the changes or the transaction, because something that's viewed as a sacred right is being changed, and that sort of leads to there being supplemental indentures, amendments, and whatever. So you're determining whether those are allowable in order to do the transaction.
Sometimes the sacred rights require 100%, but sometimes they can require just one. They sometimes key off an adversely affected lender. So that could be one lender, it could be a small group of lenders. It's not necessarily unanimous consent, but it's certainly giving an individual consent right to a lender who would be adversely affected by a particular action under the agreement. The Serta case from the Southern District, which was decided in March of 2022, was, as I said, it was an earlier transaction. It went through some other proceedings in state court. But essentially, again, you had both a new money, first out super senior tranche, as well as some rolled up second out super senior that had been previously with the legacy 1Ls, and 2L debt held by the participating lenders. And again, once the case actually got heard on the motion to dismiss on the merits of the claims, again, a key contract claim alleging that the exchange of legacy debt held by participating lenders was not authorized and done as a true open market purchase, has survived. And again, this is significant because the term open market purchase occurs so frequently in these credit agreements, has kind of been inherited from the world of bond transactions, But I have yet to see a credit agreement where it's actually a defined term. So when a court faces a transaction that has been authorized as an open market purchase, the question is it or is it not an open market purchase? And can you construe that as a matter of law to clearly authorize the transaction? And so far, courts have said, no, this is a term that is ambiguous and that is therefore going to be subject to discovery, potentially expert testimony, and it cannot be resolved on a motion to dismiss. And so that is an important outcome in the CERTA transaction. That court also upheld a claim for breach of the implied covenant of good faith and fair dealing, and held that the no action clause in CERTA was different because it wasn't one of these sort of souped up and modified no action clauses, but was just a traditional one that was applying to actions to exercise rights to the collateral or to enforce guarantees. And the court basically just said that's not what, this transaction doesn't touch that. It's not within the purview of that no action clause. But it dismissed claims based on sacred rights to pro rata payment. This was one of the credit agreements, I think Damien mentioned earlier, where the pro rata rights were really addressing the rights within a particular class and not as between a legacy 1L class and a new super senior class. So that was dismissed. And so that's the CERTA transaction. I think it's worth mentioning the TPC case just because Josh Sussberg mentioned this earlier. It was a case decided in Delaware Bankruptcy Court in July of 2022. It was under a bond indenture and not a credit agreement, and it did not involve the traditional uptiering. There was no roll-up in the transaction of the existing notes, but there was an issuance of new super priority notes. And because it applied New York law, and because it dealt with a sacred right that was very similar to the one that was at issue in Trimark, I think it really highlights, and I'm not going to walk you through the sort of nerdy details that litigators pay attention to about the wording of the sacred right and how the courts have analyzed it. But if you ever want to take a walk down that dark path, what you see is that the way the state commercial court parsed the language and the way a bankruptcy court decided the issue were really quite different. And in particular, that it was important to the bankruptcy judge that, this idea of looking at a provision dealing with the application of collateral proceeds, he very quickly just honed in on one provision and said, this is the provision that deals with collateral proceeds. Whereas, arguably there were many, many provisions in the indenture that dealt with the treatment of collateral proceeds, but he honed in on one. In my experience, that's different than how a state court judge would parse an agreement. But Judge Goldblatt is a very, very, very exceptional mind in parsing this language. But he said the indenture at issue, he looked at the fact that you could release all the collateral with a 2/3 majority consent. And his view was that subordination was actually a less drastic action under the bond indenture than releasing all the collateral. And despite many arguments to the contrary that it's not necessarily less drastic, that was a very dispositive issue for him. And you can come away with the sense that the way that a bankruptcy judge will look at these transactions is very, very different than a way a state commercial judge is going to look at the transactions in the larger context of the bankruptcy. It looms large. The pace at which the issue was decided and the way in which it was handled was just different than what you would see in state court. The last case that I'll touch upon is the Board Riders transaction. That was the most recently decided in October of 22. And again, it was a traditional uptiering transaction. It involved both first lien and second lien. And, you know, the first lien and the second lien end up behind new money and a rolled up exchange of the legacy first lien loans. Here again, the state court judge, and Judge Masley in Board Writers was the same judge that had initially denied in the CERTA case, the state court effort to get a preliminary injunction. And again, when you look at these issues and the risk that they pose, you know, the way the court looks at a transaction, when they're faced with stopping a potential transaction, and the burden that the objecting party has to meet to get a preliminary injunction, that's a very different posture to think about one of these cases than if you are on a motion to dismiss, where the presumption is almost reversed on the plaintiff's side, and where all of the allegations are going to be deemed true and every inference is going to be drawn in the plaintiff's favor. So Judge Masley reached a very different analysis and outcome on the motion to dismiss than she did on the preliminary injunction in the CERTA case. But the contract claim survived, the good faith and fair dealing claim survived. And again, she had a similar reaction to Judge Fela in the CERTA case, looking at this term, open market purchase, finding that it's ambiguous, right? And on the two sides of open market purchase, right, you have the company and the participating lenders are saying, look, this is a situation where you have a single buyer and a captive group of sellers. And as long as you're talking about a arm's length transaction and buyback, that's an open market purchase, okay? And it's not correct that you have to have an opportunity for everyone to participate. And on the other side, you have the plaintiffs who are arguing, no. An open market purchase is something very specific, and it is a situation where you're operating through an established market, usually through an intermediary, a broker, an agent, and you don't have transparency. It's not taking place in a smoke-filled room, you know, behind closed doors. And this is a known quantity, it's a term of art, and it's got to be subject, you know, to expert testimony. And so that is all yet to be ruled upon definitively. If those cases go forward, how the court ultimately interprets open market purchase could have a big effect on everybody.
Now, most of the cases up to now have been on loan documents, minority and majority lenders. It sounds like with TPC, and now there's a new court case, which is now starting to get us into the bond world. And with the lenders, it was always, you gave the requisite number of holders, gave direction to the agent, they just did it, and it worked. I know we sort of focus on bonds in our lives. Real quickly, what might be some issues to look at from the bondholder perspective? What's different, particularly since you might have to have supplemental indenture or amendments done under indentures?
Yeah, so I'll talk a little bit about how an indenture trustee might kind of look at these situations, particularly where they're being asked to sign a supplemental indenture, release collateral, things like that. And the trustee is likely to feel caught in the middle there between a majority who wants this transaction to happen and a minority who doesn't, or you could at least envision a minority coming forth and saying after the fact, you know, you shouldn't have done that transaction. I think though generally their inclination, trustees, would be to accommodate the majority. Those are the people who can consent, direct, indemnify, but also have an eye on the minority and kind of be cognizant that they may be being prejudiced here. And I should say, I think different trustees will approach these situations differently, and each situation is unique, but just give you an idea of some of the issues. So if a trustee is being asked to do X, the first thing the trustee is going to do is go to its indenture and say, okay, what does my indenture say about doing X? But before I get to that, there's a few provisions that indenture trustees, they're kind of in the background a little bit, but relying on, and they're standard provisions in basically every indenture. I'm just going to summarize them really quickly. I've got slides on them, but trustees are entitled to rely on certificates and opinions Trustee doesn't have a duty to ascertain whether a particular transaction is prejudicial to a group of its holders. It's not liable for errors in judgment unless it was negligent in ascertaining the facts. And the trustee is entitled to rely on advice of its own counsel. And if it acts in reliance on that advice, should be fully protected. So if we go to, I've got a slide on, let's look at the supplemental indenture provision. And
Mark, why don't we just summarize real quickly?
yeah, so basically, most of these provisions say that the trustee shall execute a supplemental indenture if it gets certain documents, board resolution, evidence of the consent of the holders, opinion of counsel, officer certificate. And the indenture set out what a certificate or opinion has to say, okay? So with that as background, knowing time's short here, I think the way the trustees, there are various things that would be going through the trustee's mind at this point when they're being asked to take this sort of action, say signing a supplemental indenture. One might be to just look at the indenture and say, well, the indenture says I shall sign a supplemental indenture if I get these 3 or 4 documents. I got these 3 or 4 documents, therefore I'm going to sign the supplemental indenture. In fact, I might be opening myself up to criticism if I don't sign the supplemental indenture. So let's just go ahead and sign the supplemental indenture. Another thing that might be going through the trustee's mind is, hey, there's some risk here and I'm being asked to do something. I'm entitled to direction to do that and indemnity from the bondholders who are asking me to do it. Because there's a reasonable risk, chance of risk or litigation. A third thing might be commencing some sort of proceeding if it gets to that point. I don't think usually it will, but commencing a declaratory judgment or trust instruction proceeding to get court court order on what it should or should not do in that situation. And then
all of this is really, I think what we're saying, everything seems to be in flux, isn't it? That we have we have major evolving trends and arguments on all sides. And I think what we're really trying to convey to everybody is that this is a big issue in the industry, but there are a lot of open issues and it's still being litigated. It may turn to settlements, but this is something that we think we're going to be confronting a lot in the next months and probably years. Yes, and particularly as documents evolve. And you always get back to the document. Damien, that's what you would tell anyone, right? Read the damn document. Okay. Well, anyway, obviously, all the sessions that have gone on forever. We now have the lunch scheduled upstairs. I'd like to thank the panel. Anyone have something final they want to say? Or we have time for lunch.
okay.
Okay.
Great.